yesterday's oral arguments in front of the Supreme Court of the United States, by all accounts, kind of didn't go so great for Section 2 of the Voting Rights Act in terms of its future. The Callais versus Louisiana case has been watched carefully since the last term. And the conservative justices on the Supreme Court yesterday made it pretty clear that they didn't think that the Voting Rights Act pretty much needs to be around anymore. And it was outrageous and it was disheartening, but ACLU Louisiana Executive Director Alanah Odoms joined me. We talked about those oral arguments, but we also talked about solutions. And we talked about how the injustice needs to be overcome and how the power of the people is going to do that. Take a listen. And joining me now is Alanah Odoms, the Executive Director of the ACLU of Louisiana. Alanah, I had to have this conversation with you after yesterday's oral arguments in Callais versus Louisiana in front of the Supreme Court of the United States. Just quickly, get our viewers up to speed on how we even ended up having to have arguments again in this case in front of the Supreme Court.
Good morning. Thank you so much for having me. So what we have here is a classic case of the state of Louisiana discriminating against voters of color by drawing a map that significantly diluted their voting power, and a remedy that the federal court suggested, and the states abiding by that direction of the court and drawing a second Black congressional district, a second opportunity district, whereby a candidate of color was elected and went to Congress, Cleo Fields. And so we had a Section 2 violation, and we had a remedy that the state itself and the legislature drew. And then we have a group of white voters who sue and say that that race-conscious remedy was in fact a violation of the Constitution. And unfortunately, the court decided to hear that argument, and that is the arguments that we heard yesterday in Louisiana versus Callais.
Yeah, so I had covered here at the Katie Phang News Channel a few months ago, actually, when it was announced that oral arguments were going to take place again on this case, that it was unusual because the Supreme Court justices said, focus on just this one issue, come back in October in our term in the fall. And it was, I think, foreboding, I guess I would use the word, Alanah, at the time that Clarence Thomas took the time to say, because it pretty much was a scheduling order. It was like, come back and we're going to explore more in depth this issue of Section 2 of the Voting Rights Act. And Clarence Thomas, of course, had the audacity to be like, I don't know why, because we could just decide this right now. Again, I think foreboding and kind of predicting kind of how oral arguments went yesterday. Talk about why the skepticism that we heard from the conservative Supreme Court justices about not only the viability of this map, but why Section 2 of the Voting Rights Act even needs to still be around.
So we heard the conservative arm of the court really talk about this idea that race consciousness shouldn't really exist in the redistricting process. And they framed it more as, what if we are just looking at partisan redistricting? What if states are simply trying to accomplish the goal of having a certain number of Republican seats, having control by a certain political party, which completely obscures the important determination that Section 2 requires, which is a finding that through a very exacting test that the state has discriminated against voters of color and has diluted their voting power. So it's almost like they just skipped that entire jingles precondition analysis and said, doesn't partisan interest trump the idea of whether or not we should consider race? And I thought Director Nelson did a fantastic job of redirecting the court to say, no, we are looking at a state that has discriminated against voters of color. And we're looking at a record that demonstrates racially polarized voting, where candidates of color are not elected, even when they are the right party, if you will. So white voters are not choosing Black candidates, whether they are Republican or Democrat. That's what is happening in the state of Louisiana and always has. And so it was really, I think, a very it was very I think we've heard this over and over again from the conservative justices wanting this idea of like a colorblind process. Why do we have to use race? And I thought that Director Nelson properly, redirected us back to, yes, you can use race once you've found a Section 2 violation, which shows a prima facie case that you have, in fact, discriminated against voters of color.
Yeah, and Alanah, I want to remind our viewers that the Voting Rights Act, which was, I think, one of the most critically important aspects of trying to move this country ahead, to make progress in ways and in a space that is just so impactful when it comes to voting, that there has been an erosion of the Voting Rights Act in very obvious ways. And Section 2 is the one that everybody's just kind of holding the door, right? Like making sure that we can protect it for as long as we can, because I think it's an insult to communities of color to suggest that the irony is that these justices themselves are being race blind. I mean, it ignores traditions and histories that should bring shame to states like Louisiana and especially our southern states, right? To ignore just decades of racism and an institutionalized racism that's created these barriers that the Voting Rights Act was created to help us overcome.
That's exactly right. Katie, when you look at the history of voting in the state of Louisiana, we have never had an African-American person elected to a statewide office. The reason why Section 2 is so important, and the reason why there is no time limit on a statute like Section 2, is because for generations, there has not been anyone to represent nearly 1/3 of the population in Louisiana, 30% or more of our population, and rather upwards of 40% of our population is a population of color. It's African-American people, it's Hispanic people, it's Vietnamese people, all kinds of people. And we've never had anyone to represent those people statewide. Of course, Section 2 doesn't say that is the only analysis. Section 2 takes us through several preconditions, which are very hard to establish. But it does say that after you reach those conditions, which the Robinson plaintiffs did in federal court, that you have to look at the totality of the circumstances. And the totality of the circumstances in a state like Louisiana shows that the history is strong. The history of racial discrimination is strong. The history of racially polarized voting is strong. And that even today, we do not see that candidates of color can be elected from districts where they are submerged under the power of a larger white majority. And that's unfortunate.
Well, it's not only unfortunate, it is an injustice, because then you don't really have, I've had the privilege of spending time with several members of Congress, as well as a lot of people, because I urge people to run for local, state, and municipal politics all the time here, because I think it's important, because all politics is local. But there is something about the lived experience that makes our democracy richer. And if you don't have that lived experience that is unique and different that gets represented in Congress as well as on the state level, then you're cheating people of true representation. Alanah, doesn't this remind you also of that BS that's happening in Texas? Because with the redistricting, you have the Department of Justice under Trump that threatened Texas to sue, alleging that these districts were illegal. And yet those were districts that were drawn by the Republicans themselves and approved by the Republicans themselves. And then you come to places like Louisiana, where you have maps that are drawn by the people that control the levers of power. And then suddenly they're bad. Suddenly these maps aren't legal anymore.
There's a real dissociative nature about what's happening. It is cognitive dissonance. It's really schizophrenic how you can put forward these maps and albeit to do so in a way to accomplish your political goals. Folks here in Louisiana know that those maps, that additional district and the way in which it was drawn, in fact, to accomplish political goals as well. So if this idea of like accomplishing political goals of the parties is a center idea, the Republican Party decidedly accepted this map based on their political goals to harm the people that they wanted to harm and to protect the people they wanted to protect. And they also thought and believed that it complied with Section 2. And now that reversal, it is, again, I think it's cognitive dissonance. It is also quite disingenuous. I think this group of voters, and in particular, this attorney essentially who's been bringing these cases for a very long time to try to eliminate, I think, representation of minority communities in states across the South, we really see that these are not a group of plaintiffs that were deeply invested in this process and who were really, deeply committed and connected to the political process. This is an attorney who is working on this particular issue to minimize the voting power of communities of color, who strategically put this case together. And you see the results. It's really, it's a huge injustice. But I just want to go back to a point that you mentioned around the significance of having representation in the states. So I used to be the deputy general counsel at the Louisiana Supreme Court.
I saw that. Yeah.
And I worked for a justice, our first African-American Chief Justice of the Supreme Court, Justice Burnett Joshua Johnson. And the way Justice Johnson actually was able to get to the position of Chief Justice is she had to sue under a 1980s Section 2 voting rights case called Chisholm. And in that case, plaintiffs in New Orleans sued to ensure that voters in New Orleans could have a district that was drawn to represent their interests and to be able to elect a candidate of color. And prior to that case in the 1980s, the court for 179 years had been all white. And that case itself allowed, essentially, the court had to formulate a remedy, which was to allow an additional seat to be put on the court for a period of years until the new redistricting cycle, until the new census. But that was the only way that voters of color would not have been packed and cracked into adjacent districts where white people were the majority. And so her leadership alone, Justice Johnson, allowed for several key policy initiatives that changed the face of the state of Louisiana. Under her leadership, which went on for 10 years, the state tackled its highest in the nation incarceration rate for the first time. And it, in fact, passed a suite of legislation, 10 pieces in all, that lowered our overall incarceration rate by almost 20%. And over the course of the decade that she was in office, saved the state $270 million. 70% of which was reinvested back into programs that help with addiction, help with education, and help with all kinds of things that we know set people back on the right track, but also help to protect and preserve the rights of all people in the state. That is not possible. When you talk about having representation that matters, you have a Supreme Court justice that looked at a state that has the highest incarceration rate in the world and wanted to address that based on the fact of her lived experience as a Black woman and her commitment to ensuring that racial discrimination did not persist in carceral systems in the state. That's powerful.
And I have to say that I am grateful that you are continuing a legacy like hers in the work that you are doing, because, a lot of people are saying the fix is in now, Alanah, considering the way that oral arguments went yesterday. When do you think we could get some type of decision in light of the fact that a majority of the arguments and briefing had already been done pretty much last term, and yesterday was pretty much just the supplemental oral arguments? Do you think there's going to be a decision quickly on this from the Supreme Court?
Katie, I don't know. I'm not certain about that, but we do know that whenever the court renders this decision, it will be a seismic decision. I hope, though, and I remain cautiously optimistic, as does our entire team, because here's where I don't think the state carried its weight. If, in fact, it intended to put forth a new test for what Section 2 should look like, they failed. If, in fact, they wanted to articulate a new standard, they did not do so in a cohesive manner. And I think that was very clearly articulated at the end. They may very well not like the jingle standard. They may very well want it to be changed to something different, but they could not decide amongst the various parties, the DOJ, various arguments on their side. They could not come to a conclusion as to what that new standard should be. And so to strike down 40-year-old precedent for mere conjecture and a lack of a record to demonstrate what it actually should be according to them, I think they fall short. And so I really believe that there is hope for us. I believe that, as you said, Section 2 being the most powerful regulation to prevent racial discrimination in voting, the entire court knows that. And I think the way in which we are moving forward especially with the powerful voices, I think, of the of Justices Kagan and Sotomayor and Ketanji Brown, really demonstrating that Section 2 is really just a tape measure. It is really just a yardstick to determine whether or not states are continuing to discriminate against voters of color and not provide them equal access. That is something that we know there's a compelling state interest that we don't discriminate against people in voting practices. And I think, that's something that we're really hoping that is, carries the day.
I will say I also had the privilege of spending time with my good friend Jacqueline De Leon from NARF, the Native American Rights Fund. And she was on this channel to talk about the Chippewa Indian case and the amicus brief and all the other work that's being done to highlight the fact that Section 2 of the Voting Rights Act doesn't just speak to protect one community of color. It actually is there to protect all Americans, right? But to also highlight and to remedy injustices and done in ways that are fair. This is not some skewed hackery that is happening that we're seeing in Texas, for example, Missouri, North Carolina, even in my home state of Florida, with this revisiting of a census to be able to redistrict. I mean, these are things that are rectifying just decades and decades of wrongdoing. I always would love to bring solutions, Alanah, to the viewers and to Americans, because I do think this is just a hammer in search of a nail moment, unfortunately, for Republicans and conservatives that are seeking to find an early demise to the Voting Rights Act. You guys do such important work kind of writ large at the ACLU, but I know that you've been doing a lot in Louisiana. Talk about what people can do pragmatically in the event this happens and we don't get the ruling we want from the Supreme Court on this decision in Callais. How can we still fight back as voters? What should people be doing now in anticipation of a November 2026 election period? How can they make sure that their voices are still heard, even if, you have active kind of conspiracies going on to steal this vote from communities of color?
So it's so important that voters stay advised and connected to the process. So we have a special session potentially that may be called in the state of Louisiana to change the time limits for qualifying.
Okay.
That might seem like something merely administrative, but in fact, it is designed to respond potentially to what the Supreme Court may do to narrow or weaken Section 2. So it's really important to stay connected with organizations that are doing this work to be able to show up at these sessions, be able to have their voices heard, to say, frankly, don't do this in our name. If you're going to do this, you have to know that there is a significant population that does not agree and will voice its consent. We have to start using our power of civil disobedience and non-cooperation. It is really important to demonstrate that if you don't have the numbers in the legislature or in Congress, the power of the people is still the most powerful voice in our entire democratic process. We do have a democratic process, which means it is a process where people's voices still matter. And so I would say, raise your voice. I would say, stay connected to people doing the work. I would say, show up at these various legislative hearings and continue to make your voice heard, that this is not something that you want, and that fair opportunity means fair opportunity for all. And if we start to curtail or eliminate the rights of certain groups, we may end up in a situation where no one has equal access based on their particular qualifiers or their ethnic background or their disability status or whatever. And so it's a very slippery slope that we all need to realize. We are our brothers and sisters keeper on this matter, and we do need to stay actively involved and use our power, use our voice. And we also need to be making sure that we are pushing back and not cooperating when these kinds of actions take place.
Yeah, I'm just going to chime in and say amen. And I'm also going to say, make sure you are registered to vote across the United States, especially in Louisiana, and make sure you keep track of your voter registration status. There's some really wonky stuff that happens to the voter rolls. And you know what? Also, to your point, understand, I love the way that you just said the slippery slope. That is a legal concept we talk about a lot in the law. But really, again, it's the hammer in search of a nail, right, Alanah? It's not just the blacks today. It's the Asians tomorrow. It's the Latinos the next day. And then you know what? I don't like your disability status. Oh, I don't like this about you. They're always going to be looking for a way to make this country be a reflection of who they are. And if they don't like you, they're going to find ways of marginalizing you and disenfranchising you. Alanah, how can people find you and the work that you are doing at the ACLU in Louisiana?
You can follow us at laaclu.org. You can also check us out on social media. We're on TikTok. We have a new TikTok account, so you can follow us there. And you can also obviously follow us on Facebook and on Instagram as well. I want to say one thing just to close us out, Katie. The ACLU and other groups like Black Voters Matter and Power Coalition and many other organizations have been advocating for the reauthorization of the John Lewis Voting Rights Act.
Yes.
When we're talking about solutions, we have to talk about how the power of Congress to continue to protect and uphold our fundamental values is still very important, even though we do not have a Congress right now that is situated to do that. I think it is important to recognize that we still have the values of the John Lewis Voting Rights Act that we want to protect and uphold. And so, we saw that there were a wave of new candidates that entered the political process based upon significant injustice in our nation. There are many people that I think should be thinking about running for office, as you say, to think about maybe not in 4 years, maybe not in 8 years, but we have to think about a long game. It should be in our priorities as progressive people, as people who want to protect freedom and equality, that we need a federal voting rights statute. We need to reinitiate. We need to recommit to that. We also need to be doing it in the states. In the states that have the power to do so, having a voting rights act in the states is something that we can show to demonstrate this is not just something that we want at the federal level. We will do it and protect voting rights and protect minorities and protect communities of color wherever we can. And we can do that at the state level as well.
Alanah Odoms, I want to say thank you as an American, as a fellow lawyer. There are a million things that you could be doing, but you are focusing on the work at the ACLU of Louisiana. I thank you for the speed by which you were able to meet with me to talk about what happened yesterday in Callais. We will watch it carefully here, as I know you will. And I urge everybody who's tuning in right now to please show support for the ACLU of Louisiana and for the hard work that Alanah and others are doing. Alanah Odoms, thank you again for joining me. I appreciate it.
Hey, my pleasure to be with you. Thank you so much.
Thank you.
Katie Phang here. We launched the Katie Phang News Channel in partnership with the Midas Touch Network so we could bring you the latest in legal and political news. Straight, no chaser. So if you're a fellow truth teller, hit that subscribe button and share the word about this channel so we can build a high information America together.